I'm Mike Hackard. Real estate is one of the biggest flashpoints in trust and estate litigation. Family homes, rental properties, and even commercial buildings can quickly become battlegrounds when loved ones pass away. Today, I'll walk you through the three most common real estate battles we see in California: trust and estates, partition actions, evictions, and contested sales. 1. Partition actions, when co-owners can't agree. Imagine this. A parent passes away and leaves the family home equally to three children. One wants to sell, another wants to keep it, and the third isn't sure. What happens? In California, any co-owner usually has the right to file a partition action, a lawsuit to force either the sale or the division of property. In practice, most cases end with a sale. The court orders the home sold and the proceeds split among the heirs. Adjustments can be made if, for example, one sibling paid the property taxes or mortgage. California's new Uniform Partition of Heirs Property Act gives heirs a chance to keep property in the family. If one sibling wants to sell, the others can buy them out at fair market value before the court forces a sale. Partition actions are powerful tools, but they can also tear families apart. 2. Evictions, when someone won't leave. Another common fight: when someone is living in the property and refuses to move out. It might be a sibling who stayed in the house, a tenant who stopped paying rent, or even a caregiver who claims they were promised the home. Trustees and executors have legal tools to regain possession. Unlawful detainer eviction, a fast-track court process if the occupant has no legal claim. Civil ejectment, a full lawsuit when someone claims ownership rights. Probate petitions, asking the probate court to declare the property part of the estate and order surrender. What trustees can't do is take matters into their own hands. Changing the locks or shutting off utilities is illegal. You need the court's authority. 3. Contested sales. When beneficiaries disagree, many estates require selling property to pay debts or divide assets. But disputes often erupt over how the property is sold, to whom, and for how much. In probate, beneficiaries can object to a proposed sale. If they do, the court steps in and sometimes even allows overbidding in open court to ensure the estate gets the best price. In trusts, trustees usually have broad power to sell property, but beneficiaries can still object if they believe the trustee is breaching their fiduciary duty, for example, selling below market value or favoring a friend or relative. Transparency is critical. Trustees should share appraisals, offers, and sale terms. When they don't, litigation often follows. Preventing real estate battles. The best way to avoid these conflicts: smart estate planning. Clarity. Be specific in wills and trusts about whether property should be sold or kept. Avoid co-ownership. If siblings don't get along, don't force them into co-owning property. Choose the right trustee. Pick someone who's fair, capable, and transparent. Communicate intent. Let your family know your wishes before disputes arise. Real estate is often the most valuable and the most emotional part of an estate. Partition actions, evictions, and contested sales can drag families through years of costly litigation. If you're facing one of these disputes, don't go it alone. Get legal guidance that balances protecting your rights with preserving your family's legacy. I'm Mike Hackard. Thanks for watching.